Number 1.
Who's in item number 1?
Please, Your Lordship.
Yes.
This case is still pending in.
Please louder.
The case is still pending in Supreme Court, Your Lordship. Some more competition.
Same order, adjourned till 18 June.
Obliged.
No, Supreme Court will not open.
Yes.
July 16.
Obliged.
Number 2.
Who's appearing for the authorities?
I'm for the state, Your Lordship.
Your Lordship, in this case, I'm appearing for respondent number 16, Your Lordship. 16. 1-6, Lordship. That is Officer of AIM, Your Lordship.
Office?
AIM of Hima Mosunram, Your Lordship. The chief.
And I'm appearing for the headman, Your Lordship. That's respondent number 17.
Who's appearing for the government of Meghalaya?
I'm there, Your Lordship.
Khasi Hills Autonomous District Council? Secretary in charge of land and registration, you will be representing.
Lordship for the state, yeah, Your Lordship, yes.
Yes, what is your matter?
Yes, my matters are already self-notice to the respond as per the Honorable Court order. And our advocate, we appoint from outside, my lord, and then he told that he be ready for the BC by the next hearing. We will buy.
No, what is your case?
Your case is our PIL, my lord.
Yes?
PIL on the number, the Sangasi Himamo Sundram versus with the state government of Meghalaya. I am the petitioner in person. Item number 2.
Subordinate district council court has the power of prosecuting court. Full registrar.
He said, within the 60.
District court.
Because he courts tried, it's only 3 tribunals.
District Council Court. Apart from that, there is a district court also. Who has filed this title suit before the District Council Court?
Lordship, respond number 16, Lord. Respond number 16. I have filed, Lordship.
Respondent number 16 means?
This is Office of EM of Hima Master Ram, Lordship.
First step is lies to the High Court.
The ordinate district court goes to the judge, council court. Thereafter it comes
The High Court.
by way of petition.
227 now. 227.
That is position of this is specific.
What is the subject matter of the suit?
In this case, Lordship, we are challenging the MOU, Lordship, which was granted in favor of the petitioner, Your Lordship. We are challenging the MOU, Your Lordship.
Who executed the MOU?
Yes, Your Lordship.
Who executed the MOU?
Allegations by the petitioner is that
Who executed the MOU?
by the registrar, Your Lordship, of society.
Granting land to them.
That yes, Your Lordship.
The government had granted land to them.
Not the government, but it is alleged by them that this AM has given them the authority over the land, Your Lordship, based on MOU, Your Lordship. And based on the MOU, they have registered the MOU, Your Lordship. Now they are putting the claim on that particular plot of land based on the MOU, Your Lordship.
That is pending before the district council.
Yes, Your Lordship. Yes, Lord.
Then
Because, my lord, as per the discontinued administrative rule, the case has to be tried only the tribal people, not for the society. As per the Society Act, also the case related with society should be tried by in the.
no, but the district council court has the jurisdiction to try these issues.
No, my lord, it's not jurisdiction as per the Society Act.
In fact, notice was issued to him, Your Lordship, but till date he has not appeared, Your Lordship.
I appeared in the court.
Some of the parties, they are not tribal by entity, they are organization or the state. So it cannot be tried by the district court. It has to go to the tribal court.
Then either that court has to relinquish jurisdiction or an appeal has to be preferred that it has no jurisdiction.
They have to agitate the matter.
In the regular procedure, yes. PIL is conceived.
My lord, because the CM has filed a petition in the district court to cancel our registration of MOU also. Because as per the Supreme Court order in the state of Satipal Anand with the state of Madhya Pradesh, well, in held that in absent any provision of law regarding the cancellation of the registration, when the document is registered, it is not open to any authority under the Registration Act 1908 to cancel registration document. Even the sub-registrar, an expert general, and inspector general has no power to cancel the registration of any document which is already registered. In that provision, in that refer by Honorable Court, we challenge in the District Court also they did not accept.
You have 16, Office of the
Yes.
Siam Hima Mausaram.
Yes, Your Lordship.
They claim to have got it from you,
Yes, Your Lordship.
and you have filed the suit.
Yes, Your Lordship. Disputing the same, Your Lordship.
Who is in possession of the property? Who is in possession of this land?
If I'm not mistaken, Your Lordship, it will be number 17, Your Lordship.
That is your man, your person.
It fall under this Headman Ramashnong, Lordship. It fall under this Dorbar, Lordship.
My lord, if they say this point notable, I need that should reply in terms of the affidavit. Thereafter, our organization will reply based on your affidavit.
Under the section.
This has to be looked into. Whether it would cover public interest litigation.
I could have a fully formed prohibition form.
Hmm?
Think. Again, no, they'll cover the area. As well as who was not. And then go by the proper structure. Since it's the case is only pending. We have the rules of jurisdiction of the district office.
against unappealable orders 227. Yes, please take to. By an administrative order dated 24th March 2025, the Chief Justice directed a letter dated 20, no, what was it? By? No, by an administrative order No, by an order dated 23rd April 2025, passed by us, we directed the letter dated 24th March 2025 of Senghasi Hima Mausinram to the Chief Justice as a petition in a public interest litigation and directed the registry to register it. We also directed the matter to be listed today after service on the Chief Secretary, Government of Meghalaya, Khasi Hills Autonomous District Council, the Secretary in charge of land and registration for property within the jurisdiction of Khasi Hills Autonomous District Council, and to all other stakeholders. In those circumstances, this application has appeared, this petition has appeared in the list today. The Petitioner before this court is a sect of the Khasi tribe. Full stop. It is called Niam, N-I-A-M, Khasi, and profess to practice Sanatan Dharma. There is a serious dispute between this sect and another, also of the Khasi tribe, Siam, S-Y-I-E-M, Mausinram, and Siam Hima Mausinram, Mausinram CM ship. Over a piece and parcel of land or property in Mausinram village. Full stop. At present, it is under the control of the headman or Rangba, Shnong, S-H-N-O-N-G, Darbar, Song Mausinram, full stop. The petitioner appearing in person submits that the latter sect has wrongfully taken possession of this land and property and is preventing them from carrying out their age-old religious practices on this property. Paragraph, we observe from the records that there is also a title suit. There is a title suit, TS 74 of 2024, filed by the Siam, Mohsin Ram and Darbar against the petitioner's organization pending before
The presiding officer, Your Lordship,
the presiding officer subordinate
District Council.
District Council Court, Shillong. In which, as submitted by learned counsel for Siam Hima Mohsin Ram, a an alleged memorandum of understanding between the parties duly registered is sought to be set aside and cancelled. The relevant provisions of the sixth schedule read with the rules of this court under the chapter High Court of Meghalaya, bracket jurisdiction over district council courts, bracket close, order 2014. You read para 4 of Schedule 6. It recognizes the jurisdiction of the district council. Over civil matters with the High Court exercising a right of appeal or revision only. In those circumstances, at the moment we direct the respondent number 16 and 17 to produce the cause papers of the proceedings before the district council, together with orders that may have been passed by the said body, to enable us to pass an appropriate order in this matter. You produce the cause papers, let us see.
Yes. May it please, Your Lordship. In fact, the notice which we have received, Your Lordship, the notice which we have received from the petitioner are without annexure, Your Lordship. If he can provide us the annexure, Your Lordship. The notice which we received, Your Lordship, are without annexure.
He's just written a letter, that's all. No
Some
annexure.
Some annexure are mentioned, Your Lordship.
Sorry?
Some annexures are there, Your Lordship, as per the notice, Your Lordship.
Furnish all the annexures.
May it please Your Lordship. Lordship,
Yes.
if I may submit, Your Lordship. Lordship, the statement made in page 17, para 19 of the petition is highly objectionable, Your Lordship. Your Lordship, kindly come to page 17.
Let the papers come.
Lordship.
If it is a properly constituted proceeding in a civil court, we will release the matter.
Then, Lordship, another aspect also, Your Lordship, if Lordship in the notice, his serial number 15, he is the judicial officer of the district council. A notice has been issued by the PIL petitioner, Your Lordship.
Sorry?
Serial number 15, Your Lordship. Kindly have that notice, Your Lordship. Serial number 15. He is the judicial officer, Your Lordship, trying the case, the civil suit filed by them, Your Lordship.
Yes.
Serial number 15, Your Lordship. Lordship, kindly see serial number 15, DS Marbanyang, Presiding Officer. He is a judicial officer, Your Lordship, of the District Council Kuan.
But you see, the cognizance is on the basis of the letter. At the time of service, he has arrayed parties 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Lordship, he is a judicial officer, Your Lordship.
Because in the letter there is nothing.
Lordship, yes, there is nothing, but a notice has been issued to him, Your Lordship, as per this notice issued by him, Your Lordship.
All right. The learned advocate for the state is requested to inform the presiding officer, subordinate district council, court, Khasi Hills Autonomous District Council, Shillong, that he might take no notice of any process of this litigation served upon him by the petition. That's all.
My lord, I already served the notice to him.
Yes,
I already served the notice to him.
I can't understand what he is saying.
My lord,
He said he had already served the notice to the presiding officer.
sir.
All right, he will say not to take any notice.
Lord,
You should not make judges parties.
Okay.
You will get all that here, huh? His service note is that all spelling, wheeling, everything we will get. And in his letter, last part.
Only, Your Lordship, the statement made in those paragraph, page 17, para 19 of the petition is highly defamatory, Your Lordship. That against also an IS officer, Your Lordship. Calling him an anti-social element, this is highly.
Page 17.
Lordship, kindly come to page 17, Your Lordship. Page 17. K, Your Lordship. Page 17, K, Your Lordship. Lordship, kindly see that K, because it's very shock and surprising. Lordship, it is given in a bold letter, in a black letter, are given a free hand to antisocial elements, that is Shri C.V. Dingdo, IAS and other. Lordship, kindly see. Then, Lordship, kindly come to para 19 at page 9.
All right, when we deal with it, you.
Lordship,
Yes.
I'm highly obliged, Your Lordship.
List this public interest litigation. Once again. On 18 June. Paragraph, we make it clear that pendency of this petition will not prevent the civil court from proceeding with the suit
Highly obliged.
in accordance with law.
In the meantime, let the petitioner provide us a copy of the annexure, Your Lordship. Let the petitioner provide us a copy of the annexure, Your Lordship.
That is also the job of the court. Is that the job of the court? That you take copies, give it to the parties. You tell us if that is the job, we will do it.
I'll ask from the petitioner.
We will open an office of giving copies.
I'll ask from the petitioner.
Please write a letter and he will furnish.
Yes, Your Lordship.
And if he does not, the law is he cannot rely upon that document.
I'm obliged, Your Lordship.
Highly obliged.
Number 3.
You make a first call. Let us see which matters are ready.
Item number 3.
Ready for hearing?
I'm ready. My Lord, may it please your Lordship. Lordship, I seek your kind indulgence, my Lord, because the learned additional advocate general is having some personal difficulties. So I pray if the matter may be adjourned for a day, my Lord.
Lordship, in fact, the matter is ready for hearing. During the last occasion, I prayed for time that there was some subsequent development. So by order dated 4/4/2025, the court has allowed me to bring certain developments on the courts. It was filed by way of affidavit, and it was replied also by the other side.
Yes.
So the matter is ready for hearing.
So who are you appearing for?
I'm appearing for the state, my Lord, respond number 1 to 4.
And I was the writ petitioner and the respondents.
The state has a role.
Lordship, because my Lord, out here, the writ apparent had to file an appeal against the order passed by the learned single judge, my Lord. Because
My lord, if I may, the matter before my lord today is a very simple matter in the sense that order has been passed by learned single judge against me without affording me a chance to file a reply or without even hearing me. So I am on a very, very limited point. I'm at best, my lord, I'm seeking a remand back to the learned single judge. And as far as lordship's query, whether state has a role, I would humbly submit, my lord, state has a very limited passing role because it's a matter of reconstitution of the managing committee of a school. So the dispute primarily is between my friend appearing for respondent number 5 and myself. So as I said, my lord, very limited ground on which I place for
You
lordship.
were the writ petitioner.
My lord, I was the private respondent in the writ petition.
I was the writ petitioner.
He was the writ petitioner. So his writ petition has been allowed. An action that I had taken has been set aside by learned single judge without my reply on record, without even hearing me on the day in question. So very limited ground.
Reply means affidavit in,
Affidavit was not
not reply, opposition.
affidavit in opposition was not filed by me. I had sought some time. Time was not granted. I personally, my lord, was on my legs in another court. My junior colleague said, please take the matter at the end of the board. That also was not allowed. Order was passed in open court in my absence without my reply, my affidavit in opposition being on record. So very limited ground, very specific ground.
I may be allowed.
What order has been passed?
My lord, if I can just take a few minutes just to explain, my lord.
No, what is the
Yes, my lord.
purport of the order?
The purport of the order is I had sent a proposal to the government. My lord, was the president of the previous managing committee of that school. So I had sent a proposal to the government for reconstitution of the managing committee. The rules as they stand require the secretary, that is respondent number 5 today, to send the proposal. For reasons best known to him, respondent number 5 refused in spite of my repeated request to send that proposal. Having no other option, I, as the president of the committee, sent the proposal to the government, my lord. Against my proposal, respondent number 5 filed his writ petition. Prayer in the writ petition was very simple, for a declaration or for a direction that government should not act on my proposal. So on the date the impugned judgment was passed, I personally was on my legs in another court. My junior colleague appeared and requested some time, 2 weeks' time, to file an affidavit. That was not granted. Observation was made that affidavit is not required. Number 2 request was made that matter may be taken at the end of the board because I was on my legs in courtroom number 3, in fact. That also was not agreed to. So bottom line being, my lord, my proposal was set aside by the learned single judge through the impugned judgment without my reply on record or without even hearing me, my lord. That is the sum total of my grievance against the impugned judgment, my lord. I was not heard, violation of natural justice. That's all, my lord.
Your proposal was to what effect?
My proposal to reconstitution of the managing committee. So the rules require, my lord, if lordship chooses, I'll take my lord through the rules. Rules require that
Imagination is not there.
Yes.
my lord. So as I had submitted, very limited ground of appeal, my lord. I am not on the merits. I am not on the
No,
factual.
what proposal you had given?
My lord, if lordship allows, if lordship kindly looks at my memo of appeal, page 180, my lord. 180.
No, what was your proposal?
My proposal was for reconstitution of the managing committee. Because the rules require that before the present existing,
How was he aggrieved?
according to him, it is only he, in the capacity of secretary, who has the right or the authority to send the proposal. So his grievance in the writ petition was, I, as the president, did not have the authority. He wanted my
What
proposal.
was the post you were occupying when you sent it?
President of that committee,
And he?
secretary
Of which committee?
of that same committee, my lord. Of my committee, he was the secretary. So under the rules,
Proposal is with the government.
proposal was sent to the government. While the government was still processing it, the secretary filed the writ petition. Prayer in the writ petition was for my proposal to be not acted upon by the government or not to be taken into consideration. Learned single judge agreed with the writ petitioner, respondent number 5 today. My proposal was set aside.
Let the person to whom the proposal has been sent decide whether it has been sent by the right person. If yes, it will be considered the proposal sent back. Finish it up. To the government.
My lord.
Which department? Which secretary?
Education, my lord. Education.
Yes, please take it. This appeal involves a very short point and can be disposed of immediately. Full stop. The dispute is between two office bearers of a government-aided school. Government-aided school.
My lord.
Full stop. One is the president of the managing committee, comma, the appellant. Full stop. The other is the secretary.
But Lordship is not only the president, because he has sent the proposals on the.
Please listen to this order. The other is the secretary. Full stop. The question is about. No, the dispute arose from sending of a proposal by the appellant to the government for reconstitution of the managing committee. Full stop. According to the respondent secretary, the appellant had no power to do so. Paragraph. On this short point, a writ was preferred. Full stop. The learned judge, by the impugned judgment and order, allowed the writ, holding that the appellant had no authority to send the proposal. Paragraph. Apart from merits, the order is challenged on two grounds. The first is that the order was passed without giving the appellant an opportunity to file an affidavit. Full stop.
My lord, sorry, my lord, if I may.
No, please don't interrupt.
Don't say anything.
That is the allegation. The second is that the order is ex parte, without proper opportunity to the appellant to present his case. Paragraph. We are not going into this latter controversy. Paragraph. We think that the ends of justice would be subserved if the proposal as sent by the appellant is considered by the government. Full stop. While considering the proposal, it will also examine whether the proposal has been sent by the right authority. Full stop. If it finds that the appellant had the authority to send the proposal, it will consider and propose and process the same. Full stop. If it finds that the appellant did not possess or does not possess such authority, the government will send the proposal back to the school. Full stop. Thereafter, a fresh proposal may be sent by the authority having power or the authority by the. That's all.
Lordship, in this case,
You are for the government.
No, I'm not the government.
Then-
I'm the private respondent.
Yes.
The proposals, as per the judgment of the Honorable Single Judge, we have already placed before the courts also. The proposals we have submitted, the secretary was already.
You are a
approved.
child of the government school or not? You are a creature of the government.
Government only.
The river cannot rise above its source.
But
So let the government consider whether the proposal has come from the right person or not. Right?
but
The appeal is accordingly disposed of. The impugned.
as per provisions.
Judgment and order will stand modified to the above effect.
Item number 4.
You have anything to say after this? Your time, huh?
Feebly open.
Okay.
My
Yes.
lord, this is an appeal preferred by the corporation, my lord, against the judgment of learned single judge in which lordship has allowed the respondent before lordship to regularize their service, who were the donor of a land. So, my lord, there's a
You are for the
provision.
respondent.
I'm for the appellant here, my lord, before your lordship, my lord.
Oh, Mohammed Zahir.
No,
My lord,
the next
item number 4 has been called.
Oh, Meghalaya Power
My
Distribution.
lord, yes. My lord, my
You
only
are ready to proceed with
My
the
lord, my
appeal?
only prayer is, my lord, Mr. Pandey is leading this matter, but due to some difficulty, my lord, there's a restriction in allowing the VC link. If lordship may kindly allowed us, the council, to appear to VC, my lord, the matter can be taken up anytime convenient to your lordships, my lord. Mr. Aditya Pandey is leading this matter.
He is a senior advocate.
No, my lord, he is my colleague, my lord. He is based in Delhi, my lord. He was present last week, my lord, due to some other matter. This matter was never called out. So he was physically present. Due to the other matters being taken up, which took time, my lord, this matter has come again today. We requested for VC, but it
No,
appears
he
there's some
can start the
restriction.
matter on VC, but then when the appeal is being heard out full-fledged, then he has to come and do it physically.
My lord, in that case, lordship,
We will also gauge the weight of the appeal.
my lord,
If it is a heavy appeal or likely to take court's time,
my lord,
then this VC thing will not do.
my lord, I appreciate it, my lord. We have,
He can start. He can open the appeal by VC.
my lord, if lordship that can be allowed, my lord, this matter can be taken up anytime convenient to lordships, my lord.
Yes, Mr. Karmoji.
My lord, I'm always available to whatever is convenient, my lord, or that date may be fixed, my lord.
When is a relative in May available or June?
My lord, I believe if this matter is taken up in the month of June, so he will be able to be present physically, my lord. But since lordship does not allow longer dates,
No,
to be
physical,
taken,
mental, virtual, we do not know.
my lord.
If it's a short matter, admission, 2-line order,
My lord,
we
in
do
that
not.
case,
We do not expect. We will not compel counsel to
My lord.
fly from Delhi to here to do it. But then, if it is a serious matter, then you have to be physically.
my lord, in
In
that
fact,
case,
my lord,
kindly
in
allow
fact, my
me
lord, the
to
matter
have
is
the
a very
VC.
simple matter. A learned single judge had requested them to consider my case for temporary appointment on the same lines as 20 other people who have been appointed by them. So, in fact, I would submit my first objection against the appeal would be that it's a premature appeal. There was no right that accrued on me through the learned single judge's order.
Oh, no, because the learned single judge has stipulated the guidelines. You have considered 20 persons, A, B, C, D, and you have taken them.
Yes.
So it implies it's kind of a precedent ratio that follow that. If you follow that, you have to take you also.
Well, that could be so. That could be it.
12 June,
My lord, I'm highly authorized.
by consent of learned counsel for the parties, this appeal is adjourned till 12 June. Full stop. At the first hearing, learned counsel are permitted to appear virtually.
Item number 5.
Obliged.
Obliged lordships.
Yes.
May I please, Your Lordship?
Yes.
Lordship, seeking some time, Lordship, to prepare the matter, my Lord.
What, on Friday you were trying to mention this matter?
My Lord, yes, my Lord, because it was the continuously this matter is fixing, my Lord. Regards to my Lord.
This is a writ petition.
My Lord, yes, my Lord. Challenging the virus of the 2 amendment, my Lord. Constitutional validity.
Which amendments?
My lord,
Which amendments have?
My Lord, the amendment. My Lord, on the amendment call, my Lord, the Meghalaya taking over of District Council Lower Primary School, second Amendment Act of 2018, my Lord. There is two amendment I have challenged, my lord, here. Section 1 has been amended and Section 2, definition clause, whereby the petitioners herein are excluded. And the Lordship has remembered. Last occasion, briefed the matters, Lordship.
So when do you want to do the matter?
My lord, no, kindly, some time may be granted, my lord. With regard to the discrimination and class sub-classification, I need some time to prepare on this, my lord.
Anytime, Lordship.
June?
My lord. June, my lord, kindly second week, my lord.
By consent of learned counsel for the parties, list this writ petition for hearing on 16 June.
My lord, deeply obliged.
Much obliged, Lordship.
Item number 6.
Obliged, my lord.
Lordship, in this matter, I seek for some accommodation, Your Lordship, as arguing counsel is indisposed.
Yes. Same. 17 June.
17.
Much obliged, Your Lordship.
Item number 7 to 10.
My lord, 7 to 10 are connected matters. So we filed paper book, my lord, but the registrars wanted also some discrepancies in that, my lord. So I'm praying for a week of time, my lord. I will rectify that discrepancies, my lord.
Yes.
Yes.
Advocate on record for the appellant. Now, in each of the appeals, advocate on record for the appellant is given liberty to correct the defects in the paper book as pointed out by the registry. By 23rd May.
Well,
when do you want the appeals for hearing?
a week after that, my lord. The first week of June, sometime. 3rd or 4th.
The corrected part of the paper book should be served by him upon the respondent. By consent of learned counsel for the parties, list this batch of appeals for hearing on 13 June.
Number 11.
The appellant's not. The appellant's not here.
Yes.
I'm for the respondent number 1. I'm for respondent 1 to 3, Lordship.
Who's for the petitioner?
Appellant is not here, Your Lordship.
What is this petition about?
It's an appeal against the judgment of the single judge. Yeah.
What was the judgment?
Please, Your Lordships.
Yes.
Lordship, I'm appearing on behalf of Mr. Goyal, Lordship, for the appellant. Lordship, he's based from Guwahati, Lordship. He cannot come today, Lordship.
What is this matter about? Ready for hearing? You don't know.
I don't have the brief with me. Lordship.
Ready for
I have
hearing?
handicap.
I'm ready for respondent number 1, but the petitioner is not here. Yeah.
Paper book filed.
Yes, already filed.
What is the matter about? Have we heard it before?
No,
Your
Lordship.
Lordship, not heard.
All right. By consent of learned counsel for the parties, this appeal is adjourned till 12 June.
Obliged, Lordship.
Obliged, Lordship.
Number 12.
Lordship, in item 12, the paper books have been filed, Lordship. The paper books have been filed in item
Here.
12. In item 12.
Item 12.
Lordship. Lordship, the
You are for the appellant.
Yes, Your Lordship. Lordship, this matter can come up after 2 weeks, Lordship, for hearing, Lordship.
Do some matters in court. Why all matters will be adjourned?
Lordship, I'm a bit handicapped today also.
No, why handicapped? Everybody is handicapped every day. Then what will the court do? Remove the cap from your hands and make the hands free. Do the matter tomorrow. 2 hours in the evening is enough for one counsel to get ready in an appeal.
Lordship, the conducting counsel is from...
What conducting counsel?
From Guwahati, Lordship. I'm a bit handicapped, Lordship. I'm praying if it can be listed on 27, Lordship, to your Lordship's convenience. 27 of this month, Lordship.
Then you go to June. Mr. Deputy Solicitor General, you consent to 14-15 June. Are you suffering an interim order?
Otherwise, it's a very short matter, my lord. In fact, the learned single judges allowed the writ petition, my lord. And I don't understand why they have filed this appeal. Learned single judges granted the relief, my lord, substantially to them.
One very senior, this is just a joke.
My lord.
The judge in Calcutta High Court, who was presiding over the division bench, when he was told that, my lord, I need instructions in the matter, he said, what type of instructions? Material instructions. Then you will do the matter.
My lord.
Lordship, there's some issues relating to law which is involved, Lordship. This matter.
But the point is very simple in this matter. Here, what happened, my lord? He is serving in Assam Rifles, my lord.
Assam Rifles?
In Assam Rifles, my lord. In JCO, Junior Commissioned Officer, my lord. Now, his claim is that there were certain adverse entries in ACR which were not communicated to him. And his case is that, so he filed a writ petition with Learned Single Judge, my lord. And he was superseded in promotion. Learned Single Judge directed that communicate the adverse entries to him, allow him to file a representation against that, and then you consider, the department to consider his representation, my lord. They are relying on some decisions of Supreme Court, my lord, Sukhdev, which clearly say, my lord, that communication of each adverse entry, that rule is only applicable to civilian department, my lord, not to the armed forces.
That is our basic ground, Lordship. We are saying that the respondents could not have relied upon the uncommunicated ACR, Lordship. So on that ground, we are seeking for promotion. Lordship can have it after on the 27th.
That is the best possible order that has been passed, directing the respondents to consider your case.
Yes, my lord.
Lordship, but our basic ground is that the uncommunicated ACR itself cannot be relied by the respondents, Lordship. It should be ignored.
But then will the court write to your ACR?
No, Your Lordship. We are saying that the uncommunicated ACR should not be taken into consideration, and the direction should be issued to the respondents to take steps for passing any appropriate orders, Your Lordship.
That means that without any career records being considered, you will be promoted in
No,
the
Lordship,
army.
by relying on the other ACRs, Lordship.
The reason is technical, not communicated. So, ACR, remove, give me promotion.
That's what they want, my lord.
No.
This is what they want.
Anyway, when you want to do the matter?
27, Lordship. Any date, Lordship, convenient. Any date, Lordship.
May.
I'm praying for 27, Lordship. 27 May, Lordship. It's a Tuesday.
16 June.
16 June.
it is made clear by consent of parties. It is made clear that this adjournment will not be taken advantage of by the appellant to initiate contempt proceedings or to seek enforcement of the impugned order.
Hello.